Breaking news of the night is that the very first significant filing in the case of United States of America versus Donald J. Trump and Waltine Nauta, the criminal defense lawyers in the case lied. There has been much suspense surrounding the first filings in the case. Much of that suspense has centered on Judge Aileen Cannon, who was appointed by defendant Trump to the federal court after joining the Republican organization, the Federalist Society, that grooms right-wing Republican lawyers to become federal judges. Judge Cannon's ruling on the current dispute before her, which is when to set a trial date in the case, might tell us whether she is going to be as blindly devoted to Donald Trump's defense as she was when Donald Trump's criminal defense lawyers first asked her to prevent prosecutors from using evidence they obtained with a search warrant from Donald Trump's Florida residence. Every ruling Judge Cannon made in that proceeding was overturned by a panel of judges on the Circuit Court of Appeals that included 2 Trump appointees. There has not been an equal amount of suspense about how the Trump criminal defense lawyers would handle this stage of the case. From the start, all experienced observers have been predicting that the Trump side will try to delay every aspect of the case as much as possible, and that is certainly what they are trying to do in their first significant filing in the case, a 10-page pleading followed by 2 signature pages, asking the judge for an indefinite delay in the trial date. The Trump lawyers do not suggest an alternative date to the December 11th trial date proposed by the prosecutors. The Trump lawyers ask for no trial date at all and insist to the judge that a trial date doesn't really matter anyway because they and Donald Trump are expecting her to dismiss the case based on pretrial motions they promised to file. At the top of page 2 of their filing, Donald Trump's criminal defense lawyers tell the judge, who he appointed, exactly what Donald Trump expects of her. Quote, the intersection between the Presidential Records Act and the various criminal statutes at issue has never been addressed by any court and, in the defendant's view, will result in a dismissal of the indictment. The only person who can dismiss the indictment is the judge in the case who was appointed by the defendant in the case, and the defendant is now telling that judge in writing that she will do that. Quote, will result in a dismissal of the indictment. If Judge Aileen Cannon had the slightest concern for judicial decency and the appearance of impartiality, she would, of course, have already recused herself from this case and not leave herself in a position tonight to be taking orders publicly in writing from the man who appointed her. There is nothing legally improper or unusual about that line in a normal defendant's pleading, but it is extremely unlikely that there's anything in the Presidential Records Act that can legitimately get this case dismissed. But criminal defense lawyers are supposed to pursue every possible avenue of defense, including the highly unlikely. But no federal judge in history has ever presided over the criminal trial of the person who appointed that federal judge. That has never happened in our history. No federal judge in history has ever been presented with this particular sharp and obvious conflict of interest. So far, Judge Cannon has shown no inclination toward doing the right thing and recusing herself from the case. And so she remains in a position to dismiss the indictment and now has it in writing from Donald Trump that that is exactly what he expects her to do. Donald Trump's criminal defense lawyers make several reasonable points in arguing in favor of a delay in the case, including the massive amount of evidence that prosecutors have handed to the defense lawyers. Quote, the government produced more than 428,300 records in excess of 833,450 pages, consisting of approximately 122,650 emails, including attachments, and 305,670 documents gathered from over 90 separate custodians. The initial production also included some 57 terabytes of compressed raw video footage. So far, there is approximately 9 months of video footage, but the final number is not yet certain. The government has not informed the defendants when it anticipates producing additional discovery, what that discovery entails, or to even approximate when it will be in a position to fully comply with its discovery obligations under the law. The Trump lawyers mention the case of United States versus Reality Winner that saw a 16-month spread between indictment and the scheduled trial date, and they cite another criminal case involving classified documents in which, quote, the defendant was indicted on January 24th, 2019, but the case was not tried until September 12th, 2022. The virtual shutdown of the courts during COVID no doubt had something to do with that timeline, but still, these are reasonable, lawyerly points to make. The Trump lawyers say, quote, to begin a trial of this magnitude within 6 months of indictment is unreasonable, telling, and would result in a miscarriage of justice. That is normally the outer limit of rhetoric in pleadings like this. Miscarriage of justice is about as far as serious lawyers ever go in these kinds of pleadings rhetorically. But the Trump lawyers begin the document as a political document, unlike any we have ever seen in a legal criminal case. They begin with a speech that has nothing to do with the law, saying this extraordinary case presents a serious challenge to both the fact and perception of our American democracy. That is pure rhetoric that has no legal meaning whatsoever. The next sentence is very carefully written, and this is important, it is technically true. It says, the court now presides over a prosecution advanced by the administration of a sitting president against his chief political rival. That is technically true. This prosecution has been brought by the Justice Department, which is part of the Biden administration. President Biden has been studiously distant and completely uninvolved in any way with any aspect of the investigation that has led to this point. Now, when Donald Trump makes a similar point publicly, he lies. And he ascribes the prosecution not to the Biden administration, but to Joe Biden himself. He treats it as if Joe Biden is Jack Smith, as if Joe Biden is the prosecutor. Donald Trump tells the lie to his voters that President Biden is prosecuting him. On the night that he was indicted in this case, Donald Trump read a written speech from a teleprompter saying that he was indicted on espionage charges and obstruction of justice because a, quote, corrupt sitting president had his top political opponent arrested on fake and fabricated charges. That would, of course, be outrageous and un-American, if true, but Donald Trump and his speechwriters later in the same speech said, I will appoint a real special prosecutor to go after the most corrupt president in the history of the United States of America. Donald Trump promised to do exactly what he falsely accused Joe Biden of doing. That is the kind of Trumpian lie that we did not expect from Donald Trump's criminal defense lawyers, the ones who haven't quit already. The criminal defense lawyers who signed this filing have all signed their names to a lie. On page 6, Donald Trump's criminal defense lawyers tell a purely Trumpian lie in their own words, completely of their own volition. They changed the phrasing that they used on page 1 of their filing about this case being, quote, a prosecution advanced by the administration of a sitting president against his chief political rival. They changed that to calling this case, quote, the prosecution of a leading presidential candidate by his political opponent. That is a lie. And every one of the 4 attorneys who signed this lie know that it is a lie. They know that President Biden is not prosecuting Donald Trump. They know that this is not the prosecution of a leading presidential candidate by his political opponent. That line is now the lowest point that the Trump criminal defense lawyers have sunk to in their defense of the pathological liar who they are representing. We now know that the Trump criminal defense lawyers will lie to the judge that Donald Trump appointed, and that they will do it in writing, and that they will do it without the slightest trepidation that the judge Donald Trump appointed will in any way fault them for lying to her in writing. That is what they have presented to Judge Aileen Cannon on page 6 of their filing. They have presented to her not a test of her willingness to accept their lies, but a belief that she will. It is now the most important test that Judge Cannon has been presented at this early stage of the case. Will she accept Donald Trump's lawyers lying to her in writing that this is, quote, the prosecution of a leading presidential candidate by his political opponent? If she accepts that line as fact, instead of rejecting it as a lie, then she will have chosen sides in this case, if she hasn't already. And his lawyers believe that she has chosen sides. Donald Trump's criminal defense lawyers make an apt comparison for their client on page 6 when they compare his case to the federal prosecution in the Southern District of Florida of another former high-ranking government official. They are referring to Panama's former dictator, Manuel Noriega, who they approvingly cite for having asked for and successfully obtained a continuance in his prosecution, exactly what Donald Trump's asking for now. Donald Trump's lawyers don't mention what happened when Manuel Noriega finally went to trial in federal court in the Southern District of Florida. The delay of the trial didn't help very much. Donald Trump's new legal role model, Manuel Noriega, was found guilty of racketeering, drug smuggling, and money laundering, and sentenced to 40 years in prison.